The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome to Court Radio. I'm Dean Weitzman, and this is your hour to ask legal questions. If you've got them, all you got to do is give us a call at 215-227-2727. Bum, 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 bum. Whoa. Yeah, we had some excitement there today. Okay, folks, here I am, all ready for you. All you got to do is give me a call at 215-227-2727. That'll get you into the studio where you get to ask your legal question one at a time. Today is Sunday, April the 24th. It's about 50 degrees outside right now. Intending to go up to about 70 today. Enjoy the beautiful spring day, but right now, sit tight, get comfortable, and let's do some legal thinking. 215-227-2727. And if you can't call today, all you got to do is you can email me at dean@myphillylawyer.com. dean@myphillylawyer.com. That'll get you my email address, and I can respond to your questions in that fashion, or at least give them to somebody who will answer them. Okay, let's see what's happening in the news today. Well, everybody knows probably, but pop star Prince, or the artist formerly known as Prince, passed away unexpectedly this week at his home in Minnesota. And you know, it was a big shock, and nobody knows why he died. There's an autopsy going on, and we'll get answers to that. I guess it really doesn't matter why he passed away. He was an amazing artist and a force to be reckoned with, and he's gone. And too soon. I think Prince was 57 years old when he died. Let's see here. Okay. And what else is going on? Oh, this is amazing. The Treasury decides to put Harriet Tubman on the $20 bill. Bye-bye, Andrew Jackson. No more Jacksons. Bye-bye. That's going to happen, I don't know, in the next couple years or so. And so I think that's excellent. And who else? They're also changing, I think, the $10 bill. Or they will be anyway. But right now they're going to start with the $20 bill. Harriet Tubman gets the nod. What do you think about that? I think it's cool. I like it. Oh, and one other important thing from a legal perspective, the legislature has finally passed medical marijuana. And Governor Wolf last weekend signed it into law. And so you might think you can start getting high tomorrow, but the truth of the matter is that it's going to take about 18 months for that law to go into effect. 18 months thereabouts. And I've read the law. You can't sell weed. The plant can't be sold. So the only thing you can do is you can convert the plant to an oil or a pill, and you can smoke that in one of those electronic cigarettes, those vapes, or creams. You can do a body butter, THC body butter, just lather on up from head to toe and, then go out and look at the plants grow or something. I don't know. But it's coming. And you know what? Once that door gets cracked open, it's only a matter of time before all kinds of other things are possible here in the Commonwealth. We're really, like the 20-something state to legalize it. We're certainly not cutting edge by any means, but we've had some of those pot-toting politicians on court radio, and we got to bring them back on to thank them for this, because the truth is that there's a lot of people who have real, true medical conditions that this will be immeasurable in its help. Of course, there'll be a ton of normal people who found conditions that occurred, and they'll find a doctor probably to give them the prescription. Actually, a doctor isn't going to give. It's very strange. Because it's illegal federally, okay, and that hasn't changed yet, Pennsylvania needed to find a way around that federal law. And so if doctors who have a federal license to practice medicine were tasked with having to write a prescription, they could lose their license. The government could come after them. And so the Commonwealth decided that the doctors don't have to write prescriptions. They have to write a recommendation. And then the pharmacy can follow that recommendation or not, but it's not actually using the doctor's prescription pad. And that's the way. And Pennsylvania, I might add, is the first state in the union to actually have the legislature pass a law, as opposed to the citizens doing a proposition or something of that nature. This is actually the legislature, which gives it a little bit. It's a little trickier because, you know, the legislature, it can't violate they can't enact laws that are in violation of the federal law, but they're finding ways around that. It's interesting, and it's legal, and we're going to see how it plays out. 215-227-2727. I want to hear what you got to say about medical marijuana or legalizing other drugs. What do you think about that? You think legalizing drugs ultimately is a good thing? Well, I'll tell you one thing. The Commonwealth has missed out on a tremendous amount of tax dollars. And you know what? We can't afford to miss good tax dollars. You know, the kind of tax dollars that folks don't mind paying to get high, you know? So there you go. And hopefully they've already broken it down on how the tax dollars are going to get spent. And quite a bit of it is going to be spent for education, and I'm not talking about education. I'm talking real education. You know, grade school education, and making sure that schools have the right equipment and the right programs, and of course also for some rehabs, because some folks are going to need that. But this is where like real tax dollars can get spent in a productive way, and we've got to find those ways nowadays because tax bases are shrinking in other areas. All right, that's it. 215-227-2727. Let's talk to Theo from Newcastle. Line 2.
Hello.
Hi, Theo.
How are you today?
I'm doing great, thank you. And you?
I'm having a problem hearing you.
You are? Well, I don't know what that is. But tell me your question. Tell me your question,
My question this morning is, my neighbor's dog bit my son. He's riding his bike past his house. Little girl was walking the dog, about 12, and they dragged her and bit his. My insurance paid for when I took him to the hospital, and I questioned him about him taking care of the bill. He refuses. I want to know, can I take him to small claims court and win?
You can, and you probably will. Many jurisdictions have something called the first bite rule. If a dog has never given the owner a reason to believe it has a propensity for aggression, and it's the very first time that the dog's ever bit anybody, then sometimes you will not be able to establish the requisite negligence on the owner. But there are many exceptions to that rule. And breeds that generally have a propensity for violence, for aggression, like a pit bull, you don't need to show the first bite that a first bite had occurred. I would say that if I'm a betting man, and I am, you win that argument. Now, the question always is whether you'll actually get paid at the end of that process. And I can't tell you that because I don't know what the neighbor's means are or if the neighbor has insurance. Insurance, if you have homeowners insurance, insurance would pay for the bite that the dog did. So in your case, you sue the homeowner. He lets his insurance company know. They defend the claim and possibly entertain a settlement and pay you maybe before you even get to court.
Okay, well, I haven't heard anything yet. I put the paperwork in.
Good.
Small claims court, but
if he's got insurance, he should notify his insurance company that he's been sued. And they'll defend that claim and possibly call you to talk about settlement. Then the question, Theo, is what's it worth? If somebody calls you tomorrow and says, "Hey, Theo, we represent so-and-so. We're his insurance company. We want to take care of this. We want to offer you," and then they say a number. How do you know, Theo, how much enough is?
correct. All I was seeking was the money that I paid for the insurance bills.
Yeah, but what about your son? Is it was your son or your daughter?
My son.
Your son. Does he have scarring as a result of this bite? Is it on his...
It's a small scar. I mean, he broke the skin. He got a tetanus shot.
On his face?
No, on his leg.
On his leg. Okay, small scar on the leg, maybe a couple $1,000s.
Okay.
In addition to, whatever your out-of-pocket medical expenses are. But
okay.
Now, again, if that happens, because he's a minor, that money may have to be put into a restricted account for his benefit once he turns 18. These are the complications when trying to represent yourself in these cases. But in small cases like this may be the only way to go. Good luck with it, Theo. Thanks for calling Court Radio, and thanks for listening. 215-227-2727. That was Theo with his little dog bite case. My Philly lawyers represented people who have been mauled by dogs, serious injuries, and it's very frightening. And sometimes folks need not only plastic surgery, but they need, psychologists to help them afterwards with the, with the consequences of the dog bite. In any event, I'm hopeful that Theo can work his way through that. 215-227-2727. That's the way it goes. Let's talk to Christopher from Southwest, who's got something to say about medical marijuana. Hey, Christopher, welcome to Court Radio.
How you doing, sir?
I'm doing well, thanks. What do you think about this medical marijuana?
I think it's a really good thing. I'm not sure if it's going to benefit Philadelphia, but I was just curious how much of it would actually be allocated towards helping the school districts.
It's right in the legislation. The percentages of the tax base that gets split up. If my memory serves me correctly, and I could be wrong on this, I thought I remember seeing about 30% went to education.
Wow. Okay.
Yeah.
That's actually good to hear. Me being a native of, Philadelphia, that makes me feel kind of good. That brightened up my day.
Good. It's my job is to brighten your day, Christopher.
Thank you. Actually, you do it every Sunday. You and the whole crew over there.
Thank you.
First time actually getting in.
Have a great Sunday, Christopher. Thanks for calling us.
Thank you.
Take care, buddy. 215-227-2727. Medical marijuana is on its way. But no weed, no buds, no plants, none of that. It's got to be an oil. Now, it's subject to change, okay? This is all subject to change. I mean, not the fact that it's going to be legal. That's going to happen. But how it's enacted and what's going to be the methods of this law are still kind of being worked out by the Department of Health and the governor's office. So we'll see how things fly between now and 18 months when it finally goes into effect. There's going to be dispensaries all over Pennsylvania, and 25, I think up to 25 licenses for farms. I'm thinking of becoming a farmer, as a side job maybe. Kind of, my retirement. I'll get, farming in agriculture. I think it would be kind of cool. I like growing things. All right. Let's talk to Joyce from Norristown. I don't think we've talked to anybody in Norristown in quite some time, Joyce. Oh, Joyce. Joyce? Joyce?
Hello?
Hi, Joyce.
Hi.
You know, I was just
Sorry,
saying...
I'm on my cell, so it might be a little problem.
That's okay. I was just saying I don't think I've talked to somebody in Norristown for quite some time. So I'm happy that you took the time to call us.
Thank you.
So what's up in Norristown? What can we talk to you about today?
Well, actually, I want to know what recourse I would have. I was in an apartment complex, and they gave me 8 days to make a decision about renewal. And if I didn't decide within those 8 days, from the time I got the letter to renewal to the first of that month was 8 days, if I didn't decide, they would automatically renew at an increased rate. But I chose not to remain there, and I took another apartment. And now they not only took my security, which after repeated communication saying it could not be used towards rent, they put it towards the rent that they say I owed for the month that I moved out. Basically, my lease was up on 9/30. They gave me from 7/20 to 8/1, well, the 8 days to decide by 8/1 whether or not I was going to renew my lease. I was supposed to have 105 days notification. They claim they did that because my lease didn't end until 9/30.
Okay. Well, first of all, when you're dealing with leases and you're dealing with landlords, everything, your relationship, your entire relationship with that landlord and what happens and when it happens and how it happens is all contained within the lease. And so when you signed that lease day one, 1 year ago or 10 years ago, it talked about renewal. And it said in there, perhaps, that you had 30 days before the end of the lease to notify them as to whether you wanted to renew. And that if you did not notify them, the lease would automatically renew for another year or for month to month or whatever. The point is that the terms of all of your questions are within the lease. You didn't need them to tell you. You didn't need them, Joyce. You didn't need them to tell you that you had to renew within 8 days. You knew that, or should have known that, 11 months earlier when your lease was brand new.
Yes, but I didn't know what the renewal rate would be. They never tell you that until they send you the notification of renewal.
True that. And so,
okay.
Go ahead.
And according to the terms of the lease, they're supposed to give 105 days notice or prior to the termination of lease, which they did not do.
Okay, so according to the lease, 105 days before the end of the lease, they're supposed to give you the terms, the rental fee for the upcoming lease.
Correct.
Okay, so they violated their lease by not providing you with that information in a timely fashion.
Correct.
What were your damages as a result of that violation?
As a result of that violation, they kept my security for outstanding rent that they say I owed, which I felt I did not owe for the month.
What
because
month?
They violated the lease.
Well, yes, but what month are you talking about? The month from September 1 to September 30 or August 1 to August 30?
September 1 to September 30th. I moved out on August 27th.
Okay, now
they gave me till August 1st
to renew.
To renew, and I had according to them, my renewal date was September 1st, so I had to move out before then.
Okay, so the lease.
I moved out, and now they're trying to charge rent from September the 30th, and it's affecting my credit.
Right.
They put that I owe that rent, and they also took the security, which was only $200, and applied it towards the rent after telling me I could not use that security towards outstanding rent.
Okay, let me jump in here now. September 1st to September. They're trying to collect rent from September 1st to September 30th, but you're telling me that your lease ended August 30th. Is that what you're telling me?
Well, they're saying it ended up September 30th.
Well, which is it? I mean, it's in the lease. Is your original lease end September 30th or August 30th?
Yes, it does.
September 30th.
Mm-hmm.
Okay, so if your original lease ends September 30th, then you're obligated to pay rent through the end of the lease.
Even though they violated the lease by not giving me sufficient notice.
Well, the failure to give you sufficient notice might be a reason why you get to stay there longer. I can understand that. Like, hey, you didn't tell me how much I was going to have to pay, so I'm going to continue to pay you what I was paying you until I can move out of here. But leaving early because they didn't give you notice, I'm not seeing the connection between their violation and your need to leave early.
Because they told me I had to pay the increase, and I had to make a decision by August 1st.
So
whether or not I was going to pay that increase.
But that increase would have begun on October 1st at the end of your lease. They weren't asking.
No, it would have went on September 1st. That's what they charged me for. September 1st to September 30th. They charged me for the increased rent.
Even though they charged you an increased rent, even though your lease wasn't up until the end of September.
Correct.
All right. Well, now I think I understand it all, and I'm glad you kind of clarified that. So I would say if you want to, you could file in a small claims court or the district court, if it's in the county, for the area in which you lived, and sue them for the money that they've held from you and explain to the court everything you just told me. But get to the point where they raised your rent before the end of the lease, because that's important. That's the key here. You don't have to pay an increased rent. You decided instead of paying increased rent, you're out of here. And so that, to me, shows that they violated the lease by increasing your rent before the end of the lease term and failing to give you proper notice. They've got two violations. And I think that you win on that case.
Okay. Thank you very much.
All right, Joyce from Norristown. Have a great Sunday, and thanks for listening to Court Radio.
Thank you.
Take care.
Bye-bye.
215-227-2727. Let's talk to Keisha from Northeast Philly on line 1. Hi, Keisha. Welcome to Court Radio.
Oh, hi. How are you? Thank you for having me.
Mm-hmm. What's happening?
Well, I was in an auto accident, and I got a letter yesterday stating that it looks as if my ex-husband, well, we're still married, but we're not together, separated, is a part of my claim now, saying that he has...
When did you get separated?
Maybe like October of last year.
Before the accident?
Yes.
Okay. He doesn't get anything.
Okay.
He doesn't get...
I'm just wondering if my lawyer did that just because, or he might have made a phone call trying to be slick about it, because I'm like upset. Like, oh my God, like, how does this happen?
Yeah, well, I'm not sure how it happened, but I can tell you that once you've been legally separated, which all you have to do is live separate and apart in Pennsylvania to be legally separated. So
I knew that. Yeah.
Okay, so as long as you're legally separated, you're living separate and apart, then any asset you get while separated, and this is kind of an asset, it's a claim that you have for your own personal injuries. He can't get a piece of that. It's after separation. It's post separation. A claim, you have a claim for damages post separation, and he gets nothing. Besides which, his claim is based on a loss of consortium. That means that he wasn't physically injured in this accident, but your injuries might prevent you from being the good wife that he deserves, right? You can't take care of him the way he thought he was going to get taken care of. And so your injuries lay you up, and that affects him. But if you're separated, he isn't getting anything from you anyway.
Okay, I just wanted to make that clear. I'm just like, I know that he's not just going to like magically get a check because I was in an accident and he was a piece of shit anyway.
Oh, I think we got to beep that one out. Yeah, that's going bye-bye. But listen, Keisha, I appreciate your energy this Sunday morning. Have a great Sunday, and thanks for listening to Court Radio. 215-227-2727. But Keisha, she's adamant. He's getting nothing. Literally and figuratively, he's getting nothing from her anymore. And I appreciate that. Some energy. She's got some energy here. All right. Let's see. Where are we here? 215. I want to talk for a minute about limited tort and full tort because it comes up all the time. We visit this subject from time to time, but how many times do I need to hear a client call me and say, hey, don't worry, Dean, I'm cool. I got full coverage. No, full coverage isn't full tort. It's not one and the same. You can have full coverage, which only means that your car is covered. You got comprehensive collision, theft. You got all those kinds of coverages for your metal, okay? And your bank's happy because your car's fully covered and all that. But that doesn't mean you got full tort because you can have the full coverage and limited tort. Or you can have far less than full coverage. You cannot insure your car at all. Okay, but still have full tort. They're not mutually exclusive. You need to understand that. They're like one from column A and one from column B. You can pick one and not the other or vice versa. And full tort, what does that mean? Let's talk for a moment about what full tort means. Full tort means that if you're injured in this accident and you have that coverage, full tort, not full coverage, full tort, if you have it, then it means that any injury you've sustained in this accident is compensable. Any injury. An injury that affects you for a month or two and gets better, and you have no lasting effects from this injury, and it wasn't serious, there is some value there that you're entitled to collect for. Whereas in a limited tort case, you must prove that the bad person, the at-fault driver, caused you to sustain a serious injury. Serious injury. What's serious? Well, that may be in the eyes of the beholder. You may think it's serious, but a jury or a judge may not. It's not easy to define, and it's a burden that you would have to prove against the wrongdoer. But he caused this accident, you claim, and he damaged my car, and he hurt me. Why do I have to prove that he caused me or she caused me to sustain a serious injury? And the answer is simple, because you bought cheap insurance or cheaper insurance. Okay, you chose that, and what you did by choosing this cheaper insurance is you said to every insurance company in the Commonwealth of Pennsylvania, if your folks hurt me and my family, I promise I'm not going to ask you to reimburse me for my pain and suffering unless my injuries are serious. And you can't get out of that by claiming, hey, my agent really didn't explain it like you did, Dean. They didn't tell me. I wouldn't have given that right up. I mean, all I did was save a couple $100 over the course of a year. I wouldn't have given that right up if they had explained it the way you did. Well, that's too bad, because you're stuck with what you buy until the end of your policy. Unless you call your insurance company, you can switch midstream. Okay, you could call your insurance company right now, right today, and say, I chose limited tort, but I want to change that, and they'll change your premium and prorate it for the rest of the term. That's what you need to do. Okay, if you choose to, and if you don't, that's fine. I'm cool with that too, as long as you understand what you've given up and you're okay with that, so that when the time comes when you're in an accident and I tell you you've got limited tort and your injuries aren't serious, you're not going to cry too much, okay? That's all. As long as you understand what you bought, you're happy with it, that's fine. But please understand, full coverage does not mean full tort. Don't think that, because then you're going to be on a misunderstanding of your coverages. Secondly, And almost important as tort, maybe more important, actually, is having uninsured and underinsured motorists. There's been estimates that up to half of all drivers in Philadelphia are uninsured. Half! And if you are unfortunate enough to be struck by one of them and sustain some injuries in that accident, you probably will not be compensated for your injuries if you don't have uninsured motorist on your own car. Uninsured motorist allows your insurance company to pay you as if they were the at-fault driver's insurance company. And so with uninsured or underinsured motorist, you're fully protected. I want to come back to this after the break because there's a couple other points I want to make about insurance, and I'm going to take your calls on car accidents or anything else you got to talk about. We'll be back in 2 minutes.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years. You've had an accident and can't work, but your legal case seems like it's taking forever, and the bills are piling up. At ThriveVest.com, we're here to help. If you have a pending lawsuit, call us at 888-697-7352. ThriveVest.com has flexible solutions to get you money now. And if your case doesn't settle or you don't receive an award, you owe us nothing. Call 888-697-7352. ThriveVest.com. Get the money you need to get on with your life.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
I've been hot. 215-227-2727. That gets you into my world. All right, we're talking about insurance right now. You know, I got to talk about auto insurance a little bit because it comes up so often. And I want to tell you, I've had this run of bad luck with clients in the last 6, 8, 10, 12 weeks, where I actually get all the money that the insurance company for the at-fault driver has to pay, and the client doesn't want to accept it. So let's talk about that for a second in relation to underinsured motorists. Let's say that you're involved in an accident. The accident is a pretty bad accident. You've sustained injuries. You've got wage loss, some excess medical bills. I think that the value of your case might be, let's say, $50,000. Okay? But the tortfeasor, that's the person who caused the accident, they have a policy of insurance with My Fault Insurance Company, and that insurance is for the state minimum, which is $15,000 per person or $30,000 maximum per accident. But the most any one person can get is $15,000. And the insurance company gets a look at my claim for my client, and they call me and they say, Dean, we're going to offer you our policy limits, $15,000. And I go, well, show me, prove to me that's all you've got. And they send me the documents showing that they're insured, the bad person who caused the accident, only has this minimum $15,000 policy. Once that insurance company has offered up their policy limits, that insurance company will never have to pay more than that policy. That's what their insured purchased. He gave them the money to purchase a $15,000 policy, not a $25,000, not a $50,000, not a $100,000 policy, so they don't have to pay more than their policy limits if they've offered it. Okay, that's it. Now you say, well, but Dean, my case is worth $50,000. I'm going to be uncompensated for quite a bit of my claim. It's not fair. You're right, it's not. It's not just. How's that? So what are we going to do then? We're going to file a lawsuit against the wrongdoer and take that person to court and then secure a judgment against that person? You're still only going to get the $15,000 from his insurance company. The question is it likely that you will collect some of the tortfeasor's assets? Or is it more likely that the tortfeasor who only purchased a $15,000 policy in the first instance doesn't have assets that are collectible for your debt, and that person can declare bankruptcy, or that person can avoid having to pay that judgment in a number of ways, and you're never going to get it, and all the money it took for us to try that case is coming out of the 15. So this is one of those scenarios where how do you get paid for more if you are subject to the policy that the tortfeasors out there purchased? Here's the answer. You buy underinsured motorist protection. It's different than uninsured. It says if I'm hit by somebody who doesn't have enough insurance, my insurance is going to step up and pay me the difference between their policy and the value of my claim. And that's called underinsured motorist. And if you got it, you're good. But if you don't, whatever the tortfeasor has is what you're going to collect. Sometimes you get lucky and the tortfeasor has sufficient limits. Oftentimes you get unlucky and they have insufficient limits. That's the problem with depending on other people to make you whole. You can depend on yourself and get the right coverage from the beginning. All right, let's talk to John from West Philly. Hey, John, welcome to Court Radio.
How you doing?
Good, good. How's things in West Philly today?
It's all right, normal Philly day.
All right, that's a good thing.
My question was...
You could be in Kansas.
I could be, and that wouldn't be good for anybody.
No. All right.
My question was, if I had full coverage, or if I had insurance for my car, would it extend to my motorcycle if I didn't have insurance for my motorcycle?
No.
Like if I was in Lord forbid.
No.
No, not at all.
Not at all. You insure a vehicle. You can have two cars and a motorcycle and a boat. You don't get to lump them all into the same policy unless you've let the insurance company know and paid a premium for each of those vehicles. And in fact, with motorcycles, it's important because a lot of times you can't buy. See, in a car, if you're involved in a car accident, your insurance, John's insurance, will pay for John's medical expenses from that accident, regardless of how the accident happened, because Pennsylvania is a no-fault state. And so our own insurance pays for our own medical coverage.
Okay.
On a motorcycle, sometimes you can't, most insurance companies, you can't buy health insurance or the medical coverage portion for yourself. So you got to be very careful, because when you're on a motorcycle and there's a mishap, you know you're going to the hospital, most likely. And so if you don't have health coverage, if you don't have Obamacare or some kind of health coverage, then you're going to be uninsured for the health coverage portion of that loss. And ultimately, we collect that from the tortfeasor if the tortfeasor has coverage. But anyway, circling back and to answer your question, you got to get a coverage for the motorcycle independent of the coverage you have for your auto.
Gotcha.
All right?
Gotcha. Thank you.
Be safe. Drive safe. It's motorcycle weather, but, you got to be I ride myself. You got to be safe all the time.
Absolutely. I was just wondering, because, those days, at certain months you don't have to have, I don't pay for insurance because I don't ride. But, some days might pop up and, all right, I can get out here today. And I may not be covered for that month, so I was just wondering. Yeah,
you're not, and that's the day that you drop the bike and do $4,000 in damage to it.
Exactly. Thanks.
All right, John, take care, buddy. 215-227-2727. Let's talk to Reggie, line 5 from North Philly. Hi, Reg. Welcome to Court Radio.
Hey, good morning. How are you?
I'm well, thank you. What's happening?
All right. I have a question about child support.
Mm-hmm.
I separated from my kid's mom almost 5 years ago.
Okay.
And when we separated, we sat down and had agreement on how much I would pay her every month. And we also got a written signature from both of us and approved, notarized. Now, recently my kids met my lady friend, so she decided to take me to court. We went to court a couple of weeks ago, and she kept saying, I told her, I said, well, if you take me to court, you're going to get less than what you're getting. She said, let the courts decide that. We went to court. The court decided to give her less money. Now, I get a letter yesterday in the mail. She's taking me back to court because she wanted an increase.
How long has it been? How long has it been since the first court hearing?
3 weeks ago.
3 weeks ago. Okay, well, maybe she, I don't know. Maybe it's an appeal from that decision, in which case she'd be within her rights. But if it's filing a new petition, and it's only been 3 weeks since the original petition, then the second petition is going to get tossed, provided she cannot establish a substantial change in circumstances. So, for instance, she files the first petition, you have your hearing, you win, you get the lesser amount, and then the week later, you get a job making $75,000 more. Well, that's a substantial change in circumstances which would warrant the filing of the next petition. But generally speaking, if there's not something like drastic like that, then at least a year has to go by before she can refile. Oh, Reggie. Poor Reggie. Oh, well. All right, sorry, Reg. But, hopefully, even though I can't hear you, hopefully he heard me. He's there now. Okay, Reggie. No. See, this is a Monica issue. Yeah, she's... Okay, hit 5. Yo! Reg. Oh, there you go. Technical difficulties here, Reg. Sorry.
That's all right.
Did you hear? Did you hear what I said?
No, I didn't.
Okay. Here it is. Ready? Unless there's a substantial change in circumstances between the filing of petition 1 and the filing of petition 2. For instance, you get a new job making $75,000 more a year. That would warrant the filing of a new petition because of a substantial change in circumstances. Absent that, if everything's pretty much the same as it was when the first petition was filed, then this petition should get tossed as being untimely filed.
Okay.
But you know what?
Yeah.
Oh. Yeah. Gone again. Okay. See?
Hello?
Yes.
Yes, I hear you.
Okay. What was your follow-up?
You said something about it got to be untimely matter if I had got a new job.
If you got a new job in between the petition 1 and petition 2 and you were making a lot more money, then she could file that second petition.
Okay.
Okay? Did you?
All right, sounds
did you?
good.
Yo, Reg, did you get a new job?
No, I didn't.
Did you hit the lottery?
I sure didn't.
Okay. Did somebody pass away and you just made yourself a ton of money?
Not at all.
Well, then 3 weeks isn't enough time. And anytime you file a second petition for increasing, if you lose the first one and you file another one, you got to she didn't lose the first one. It's just she got an amount and she didn't like that amount. But there's an order and there's an amount. You can't file a next petition unless there's a substantial change in circumstances. Otherwise, people could just file these petitions one after the other, and drive the court crazy.
Right.
All right, so you're cool.
I'm cool. Thanks, I appreciate it. Have a good day.
See you, Reg. 215-227-2727. He's out of here. Let's get back to auto insurance. Okay, because I got a bunch of clients who I got policy limit offers for who don't want to take the policy limits. But I got to tell you that you're never, ever going to get more than the policy. Okay? I mean, I guess there's a 1 in a million chance that you're going to actually have somebody who didn't have a big policy but has a ton of assets, and we're going to sue them, get a judgment, and we're going to be able to collect on that judgment. If that's the scenario, if that's what you think is going to happen, chances are you will be disappointed in that endeavor, okay? Because you're going to spend a ton of money to get that judgment by going to court, hiring, witnesses to come on your behalf like doctors, and all for naught because you might get a bigger judgment, but you're not going to actually collect on the judgment. All right. If you got questions about auto accidents or insurance, we've been talking about it all morning, so today's the day maybe to shoot me a question. 215-227-2727. 215-227-2727. Do you know that when we're not on the air for court radio, that number goes right to my Philly lawyer? Do you know that me or my team will be picking the phone up when you dial that number any other time? See that? 24/7. All you got to do is keep that number in the back of your head. Let's talk to James from North Philly. Line 2. Bam. Hi, James.
Good morning.
Good morning to you. How are you?
I have a question for you.
I bet you do.
Okay, if I was involved in a car accident at the time I didn't have insurance, but the at-fault driver had full coverage. Now, I went through the whole therapy process. I got a settlement for $15,000. Now, my question is, am I liable for any other fees to the attorney if I didn't have insurance at the time?
Well, I don't know what you mean by fees, but if you didn't have insurance and you got a settlement, out of that settlement, you're going to probably pay your attorney, the doctors who treated you, and costs for the litigation, and then whatever's left is yours. But
okay, now this is aside the 40% that they were supposed to collect on the settlement?
That's correct. When you say besides the 40%, the medical bills aren't going to come out of the 40%. That's the legal fee. So if you had insurance, your insurance would have paid for your medical expenses, and unless you had a lot of medical expenses, then you would not have had to pay medical out of your settlement.
Okay, this is even though the other driver was at fault.
Well, the other driver was at fault, which is why the other driver paid you the $15,000. And I'll bet you're talking about the kind of case that I was referring to earlier, and that is the other.
That is exactly why I called in, because I heard that.
The other driver had a $15,000 policy. That's all they have. You can't get blood from a stone. That's all you're going to get. They got 15. You got to whack that up between the doctors who treated you on the come, right? They're not getting paid. They don't have any coverage for your medical expenses because you didn't have insurance on your car. So the doctors have given their time to you, okay, and enabled you to get a settlement. Because if the doctors all said to you, listen, you don't got insurance coverage, we're not treating you, if they said that, then you wouldn't have a settlement because you wouldn't have been able to prove that you had an injury. So you got to – now, typically, I will tell you this. Typically, in these scenarios, the lawyer would take a smaller fee, work things out so that everybody's happy a little bit. You know, nobody's going to be, retiring on this case. But, the lawyer might take a little bit less, and the doctors are going to take a lot less, and you're going to still walk away with some money in your pocket. But, no big deal.
I understand.
All right?
Thank you.
Take care, bud.
All right.
215-227-2727. If you got no insurance on your car and you end up with anything out of a settlement, you're ahead of the game. Because it wasn't long ago that you couldn't even collect your medical expenses, but the law changed. It used to be that if you had no insurance on your car, the first $5,000 in medical coverage or medical expenses came out of your pocket. How about that? Somebody else causes you to sustain injury and you can't collect it because you didn't have insurance. But the law changed, and that's good for people who are injured. And there you go. Let's talk to Willie from Burlington, my first New Jersey caller today.
Thank you.
Willie? Oh, Willie.
If you'd like to make a call.
Willie's gone. All right, folks, we got to take a quick break. We'll be back in 2 minutes right after these sponsored announcements.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years. You've had an accident and can't work, but your legal case seems like it's taking forever, and the bills are piling up. At ThriveVest.com, we're here to help. If you have a pending lawsuit, call us at 888-697-7352. ThriveVest.com has flexible solutions to get you money now. And if your case doesn't settle or you don't receive an award, you owe us nothing. Call 888-697-7352. ThriveVest.com. Get the money you need to get on with your life.
The The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. It's still April the 24th, and it will be a beautiful day today. Enjoy it. But right now, we're finishing up on Court Radio, and we've been talking about auto insurance and auto accidents and settlements. Gotten some great calls from our faithful listeners. Now we're going to talk to Gary on line 5 from West Oak Lane. Hi, Gary. Welcome to Court Radio.
Good morning, Dean. How are you?
I'm doing well, thanks. I'm doing well. What's your question?
Okay, my question is the subject that you were discussing, the uninsured or underinsured, the full and limited tour. How does that apply to those of us that are leasing cars?
Whether you lease a vehicle, good question. Whether you lease a vehicle or own a vehicle or have a note on a vehicle, the coverages available to you are identical. And so as a leased vehicle, you may have to get comp and collision and theft, which typically people refer to as full coverage. You may have to get that, but no leasing company will require you to get full tort. You must choose that. No leasing company will require you to get uninsured or underinsured motorist. You must choose that. And so whether you're leasing a vehicle or purchasing a vehicle, you have to select those coverages to protect your family. Because the truth is, they don't care. The bank doesn't care if you have uninsured or underinsured motorists, because that protects you, your body, and your family's bodies. It doesn't have anything to do with the metal that they have a loan against. So they want to make sure the metal's covered, but you want to make sure your body's covered.
Okay, thank you. I see. I'm going to have to look over my policy.
Absolutely. And you bring
up... assume that it would be... The full limits, the higher limits would be automatically included.
No. And let me tell you this also, because you bring up a good point. I've always extended this invitation to Court Radio listeners. If you ever want to bring your policy into my office, I or somebody from my staff will sit down with you for a little while, review your policy, and let you know if we think it needs to be tightened up.
Yeah, great. Okay. All right, thanks, Dean. That answers my question.
All right, take care, buddy. Have a great Sunday. 215-227-2727. Let's talk to Rick on line 2 from North Philly. Hey, Rick, welcome to Court Radio.
Good morning, Dean. How are you?
Doing great, thank you. What's up?
I have a quick question. I was involved in a workman's compensation injury at work, and I had lumbar and cervical surgery. Now, does it? If I was involved in a car accident after surgery and everything, and the other driver compounded the injury, should I have full tort insurance on my car, on my vehicle because of that now, or
you should always have full tort, because it's just one less thing you need to try to prove. If you've got limited tort, you've got to establish that the driver caused you to sustain a serious injury. An aggravation of a pre-existing injury could be serious. You could be getting on with your life, and then all of a sudden you have a subsequent accident which causes an aggravation which puts you back to ground zero. Right. And so I'm not going to tell you that an aggravation it can't be serious, but again, it's something you have to prove. You have to establish that. And I don't want my clients to have to prove that. I want them to worry about getting better and not worrying about, getting compensated and proving that their injuries are serious. And so I always recommend to get full tort. Whether you've got a pre-existing injury or not, always get full tort. And at least look at the difference. If you said, okay, Dean, it's going to cost me $1,000 more a year that I don't have to get full tort, I choose limited tort. Cool, I'm all right with that. But most of the time, it's a couple $100 a year, and it's something that you can work into your budget and afford. And on those times when you have the accident, you're going to be grateful that you followed my advice.
Okay, well, thank you very much.
All right, have a great Sunday. Thanks for calling Court Radio. 215-227-2727. So as we wrap up, folks, I just want to say that having the right coverage for your auto, there's a good chance you're going to have, unfortunately, there's a good chance in your lifetime you're going to have an accident or two and sustain injuries. And at those times, you want to make sure that you've paid into the system all these years, that at least you have the right coverage to compensate you for those injuries at that time. The most frustrating thing in the world is to pay into the system your whole life. You finally have an accident and you can't get paid because you don't have the right coverage. That's not fun. All right, guys, have a great Sunday. Thanks for